I know some of you will want to just continue to bask in the glory that is Ben Matlock and his impeccable suits. But we must continue on. I'll give you some other dreamy lawyers to look at, don't worry. Matthew McConaughey, for example. You're welcome. Okay, if you are going to hire a lawyer, remember from yesterday, one of the lessons is don't rely on advertisements. When you're hiring a lawyer, you also need to find someone who specializes in your type of case. And this is where we run into the limitations of having recommendations from friends. That doesn't mean what I told you yesterday is wrong. A recommendation from someone you trust is a good idea. Bless you. But if you need a personal injury attorney and your friend can only tell you the attorney who is really good at helping them with a divorce, those are two different kinds of expertise, and someone who's good at handling divorce is not necessarily going to be the lawyer you need to help you in your personal injury case. The second part often makes people uncomfortable, but you need to talk about money. That old saying, if you have to ask, you can't afford it. Sometimes I find that a statement obnoxious, right? Even if I can afford something, I'm not so dumb as to purchase it without knowing first. And with lawyers, right, you should definitely find out the price first, because there can be variation in what lawyers will charge you. Right? So you need to know how much they're going to charge you and how it's going to be calculated. Are they going to charge you by the hour? Is it going to be a flat fee? Or is it going to be something called a contingency fee? Those are important things to know. If you're getting paid or if you're getting billed by the hour, and if that lawyer calls you up and asks you how your day is, tell him that doesn't matter, right? Let's get down to business, because they sometimes, not trying to make lawyers look unscrupulous, but anybody who bills by the hour, I've heard plenty of personal stories about this from people who do the billing or have worked for the companies that do the billing, right? You always drag out the call at least to the quarter-hour intervals, so you can bill for that 15 minutes. Okay? So if the fee is hourly, that means you need to keep things short and to the point. If it's a flat fee, that's different. Then you should get as much out of your interactions with your lawyer as you can. And I don't mean at that point you should still exchange personal stories, but take your time, get things fully explained. A good example of this, when I went with my wife to do estate planning in case we should die, because we have kids and we need somebody to take care of them if we were both to die in like a horrible accident. That was a flat fee. And so I asked lots of questions, not to the point of being obnoxious about it, but there was no need to rush because that lawyer had charged a flat fee for that service. Another type of fee is the contingency fee. This is something that is pretty common in a lot of legal cases, but it is most typical in your personal injury civil cases. And that's why you'll see the advertisements on the billboards or social media or TV often say, if we don't win, you don't pay. That's a contingency fee. That said, that's not just the lawyers being generous with you. If they win, you can expect to pay at least 30% of the damages you receive to your lawyer. And that also means if the lawyer thinks there's a relatively low chance of winning, they're not going to take your case at all. You also need to know when you've got to pay. Do you have to pay it up front? Do you have to pay it when the service is finished? Are you going to be billed monthly for a kind of case that drags out over months? Those are all things that you need to know. And finally, you should get a contract that details your fees. And here I mean a written contract. I mean, for one thing, it's going to be more than $500. And so you will need one anyway, but you want a detailed contract that spells out your financial relationship with your attorney. And again, you also need to know those billing procedures. How are you going to pay? When do you have to pay? All right, and if the older Matthew McConaughey wasn't doing it for you, here's younger Matthew McConaughey. Right, or Samuel L. Jackson, not a lawyer in this case, right? But there you go. I know lawyers don't have a great reputation. Most of you probably already know that. I had an unfortunate student once who did not. Her father was an attorney, which kind of explains why he might have sheltered her from that. A lot of kind of that bad sentiment towards lawyers is really unfair. People don't like the, quote, blood-sucking lawyers until they need one. And then they want a lawyer who is extra bloody. You can, whatever you might think about lawyers at this point, you can trust them, if for no other reason than the legal concept of attorney-client privilege. Whatever you say to your lawyer is privileged. That may not be helpful to this point, and we need to know what privilege means. Privilege means that it is confidential. No one can legally require your lawyer to tell them what you have said. If somebody put them on the stand in front of a judge and a jury, they still can't reveal what you explain to them or what you disclose to them in your conversations because it is privileged. And it's not just that somebody can't make them, they also can't offer it freely. The only case in which they can release information you have shared with them in writing, in speech, in a personal meeting, is information you release them to share. Yeah, go ahead, Claire. And that's good. I mean, if you think about some high-profile cases, those lawyers could make tons of money writing a book about what they know, but they can't do it unless you authorize them to. You should also know that the final decisions in your case are up to you. And lawyers are there to provide you with advice and to represent you. But they do work for you. You can make your own decisions. A lot of times when you see stories that kind of touch on this, there is an attorney who has advised their client not to go on the witness stand and testify on their own trial, and their client has done it anyway. Now, this last part does not sound very exciting, and it's not, but it is important. And that is the 9 cannons. Not the kind of cannons that shoot things. That's a cannon with 3 ends. These are more referring to the rules that have made the cut as the most important. And a lot of these you might just dismiss as nice sounding things that lawyers don't actually do. One of the things that they have to do ethically is to make sure that the legal profession maintains its integrity and its competence. So part of that is about making sure that the people who are practicing law are competent to do it. And that's where bar associations come in. If you are not providing competent legal services, there are going to be consequences. We'll talk about those soon. You are also supposed to make legal counsel available. And this often means that lawyers don't only provide legal counsel to people who can pay for it. Even lawyers who are in private practice, they're not a public defender, they don't work for the ACLU or the Institute for Justice, will still take on cases on a what's called pro bono basis, meaning they're not being paid for it. They also are supposed to make sure that nobody is providing unauthorized legal practice, which is why the things I tell you in this class, will often say this is just personal advice. I am not authorized to actually give you legal advice. And part of that is because the only people who are legally authorized to do this are licensed attorneys. I can tell you what I would do in a situation, but I can't tell you legally what you should do, because I'm not a lawyer. Fourth is that guarantee of attorney-client privilege. As a lawyer, even if your client doesn't ultimately follow your advice and judgment, you are supposed to make sure that you give it, and that nothing is influencing your decisions about your client except for the interests of that client. And in terms of your client's interests, you are also supposed to make sure that you represent them completely. That goes directly into the 7th. Representing them completely also means that you provide them with fierce legal representation. And this is part, you can see from the second part, you can't do anything illegal. You can't intimidate jurors, try to suppress witnesses with intimidation. But you are supposed to represent them fiercely. This is one of the reasons that lawyers can also end up with kind of a bad reputation. They often seem mean and nasty in court. They're tearing down the character of otherwise decent-seeming people that have been asked to be witnesses in a case. But that's their job, right? And you would want them to be mean and nasty if they were representing you. They're also supposed to work to improve the legal system. A lot of times this can mean through advocacy. If they see something that is wrong with the legal system, they're supposed to bring attention to it, maybe write briefs and submit them to courts when certain legal questions come up to kind of show that lawyers want a change or think a change is important to make. And finally, they've got to maintain the appearances of the legal profession. And by avoiding scandal. And that can mean lots of things. Right? Not having personal relationships with, say, the opposing lawyer for the other side. Maybe it's a prosecutor, maybe it's just another lawyer in a civil case. It could be lots of things. Just think of it generally as avoiding scandal related to your job. So what happens when lawyers aren't living up to the 9 canons or otherwise failing their clients? If we're talking specifically about the 9 canons, there are professional punishments that can be imposed by bar associations. You can be reprimanded. That would be kind of a minor thing. It's just like a scolding. It's kind of like getting a written warning if you get pulled over for speeding. You can have your license suspended, because remember, bar associations, their core function is licensing attorneys, making sure that people are qualified to do their job. If they suspend you, you can't practice law, which means you can't make money doing your job. And if you do something particularly bad, or maybe you do the same bad thing over and over again, then you can be disbarred, which means you are no longer allowed to practice law at all. Now, what about just if your lawyer fails to provide adequate service to you as a client? It's malpractice, a lot like medical malpractice. A surgeon might stitch you up with some gauze or like a sponge to soak up blood that they forgot to remove, and you could have a horrible infection, and you could sue them for that. If a lawyer provides malpractice, then you can also sue them. That could, if you find out that the attorney that you had hired had a substance abuse problem and was not competent the whole time they were representing you, and you lost your case, that could be grounds for malpractice, for example. And in that case, right, you can't send your lawyer to jail, but you can sue them for damages. And if you lost your case and you had to pay somebody money, or you had to spend time in prison, if it was a criminal case, you can sue them for compensation. And this guy is either a hero or the most hated lawyer of all. I'm not sure quite how that works, but a lawyer against lawyers. But that's an example. In some cases, remember, arbitration is something you should always be aware of. That's another reason to get a contract with your attorney. You need to make sure if you have agreed that any dispute between you and your lawyer is going to be arbitrated, then that's probably going to be arbitrated by a bar association. And I don't have experience with this, but my hunch would be that any damages you might be awarded by a bar association are going to be less than you would get if you were to sue your lawyer in a civil case and win. Okay. And for that reason, arbitration is often not for those very serious forms of malpractice, but more in less serious cases like disagreements about fees. All right, and that's the end. I will put that slide back up so that you can finish. You do at this point need to go find the exit slip. I won't put that up on the screen again because I want some of you guys to be able to finish notes if you need to. The exit slip also reviews contract law and lawyers. Yeah, Jalen. Yes, now you can still go. You will have 10 minutes. I know the clock just ticked over to 8:05. I will make sure that it goes long enough for you guys to have the full 10 minutes. You're going to use the same notes documents you used for the do now. All right. Good luck.